Howdy again, everybody. This is Doc with Thorofan coming to you, and as everybody is well aware by now, the entire country is enthralled in the Senate impeachment hearings and trials that are going on in the Senate. But, you know, there's something else that the racing industry should be aware of that is going on up on Capitol Hill, and it is happening on January 28th, and it's a special subcommittee hearing on the Horse Racing Integrity Act. And those that are following the industry know that this is a very, very important piece of legislation that has created very differing opinions depending on which side of the bill you're on. But I do feel also that there probably are a lot of people out there that don't know exactly what the Horse Racing Integrity Act is designed to do. So of course, because at Thorofan we are all about education and giving you, the fan, the proper education to understand the issues that are going on in the industry, I figured what better time to dig into, dissect, and discuss the Horse Racing Integrity Act. The Horse Racing Integrity Act is a piece of federal legislation that was introduced by Representatives Paul Tonko from New York and Andy Barr from Kentucky. It was first introduced into the U.S. House of Representatives in 2015 and has been reintroduced in slightly amended forms in each of the subsequent new House terms. The current bill is H.R. 1754. So as we take a look at the Act, there are a number of questions that I am sure come up about the bill and its intent. So let's look at them. Before we delve into the specifics, I did want to make a quick mention about a section of any proposed bill that all should be aware of, and that is the section called definitions. Often found at the beginning of the bill, it is very important for folks to take a look at it, for that is where certain terms that are used frequently in the bill are defined as it pertains to that bill. This is important because sometimes what we perceive the definition to be will be different from how the term is defined in the bill. If a term is not specifically defined in the bill, then it is agreed that the definition is the commonly accepted definition based on a standard dictionary. Alright, now on to the meat of the bill. Let's answer the second part of that question first. While we probably don't view it as such, wagering on horse racing is technically a form of commerce. And with the advent of simulcasting and wagering being allowed through multiple platforms across state lines, it now falls under the realm of interstate commerce. This type of commerce is regulated by the federal government, and in the case of horse racing, is done so under a law known as the Interstate Horse Racing Act of 1978. This act governs pari-mutuel wagering rules on races conducted in the U.S. in order to help protect the industry and the gambler. If that act were suddenly repealed, basically no simulcast wagering would be allowed at all, and one could only wager on races going on at the track or tracks in their home state. This would be a tremendous economic hit to the industry as a whole, and so while technically the federal government could not shut down racing in a particular state, it does hold a huge chip in the game via this act. As far as why the bill is being introduced, well, that point can be argued for quite some time. But it basically boils down to the feeling that the industry has not been able to properly come together to create a uniform set of medication rules and penalties that have been accepted by all racing jurisdictions, and this is for a variety of reasons. The other feeling is that leaving the enforcement of such regulations to the industry itself cannot provide for a true independent enforcement of penalties, a kind of a fox guarding the henhouse scenario, if you will. And as such, only a truly independent authority can be trusted to both create and enforce the rules evenly and fairly for all. They feel it is the only way to bring back integrity to the sport in the eyes of the public and the handicappers. The bill covers three main types of racing: thoroughbred, standardbred, and quarter horse. This is a slight change from previous versions of the bill that did not include all three racing disciplines and breeds. The bill only deals with the areas of medication of racehorses, testing of those horses for both prohibited and permitted medications, and imposing penalties on those found to be in violation of medication and doping rules. It does not deal in any other area of horse racing rules or regulations. Well, no, not exactly. The bill basically establishes a separate non-profit entity known as the Horse Racing Anti-Doping and Medication Control Authority. This authority will be governed by a board made up of a various number of members, more on that in a bit, but run under the general principles that govern the United States Anti-Doping Agency. This authority will work out the nuts and bolts processes of collection, testing, and reporting of test results in racing, as well as any sanctions imposed. Where the federal government sort of gets involved on a higher level is that all actions, rules, and sanctions decided on by the authority must get final approval to be put into action by the Federal Trade Commission, since, as we mentioned before, some aspects of racing fall under the realm of interstate commerce. The first 7 members of the board will all be from the U.S. Anti-Doping Agency. One of those 7 will be the chief executive officer of the agency, and the other 6 will be selected from already existing board members of the U.S. Anti-Doping Agency. The other members will be selected by the U.S. Anti-Doping Agency, such to allow for 1 member that has expertise in the realm of horse anti-doping and medication regulation, 1 member who has experience as a horse owner or breeder, 1 member who was formerly employed as an executive with a racetrack, 1 member who has experience as a horse trainer, 1 member who holds a degree in veterinary medicine and has expertise in the area of racehorse veterinary practice or research in the areas of racehorse medicine and management, and 1 member who has experience as a jockey. Now, remember before where I said understanding what the definitions of terms are for a bill? Well, it comes into play here because while we all know the term jockey to mean someone who rides horses in races, under this bill, a jockey can also mean to be a driver of a standardbred racehorse. The manner in which these members are selected and what their term limits will be can all be found in the bill, and I won't bore you with further details. What I will say is that to ensure that there is no conflict of interest among members of this authority board, the bill specifically states that no member of the authority board can have any financial stake or interest in anything involving the horse racing industry, be someone who is already holding an official position in any part of the industry or board who regulates it, or be an employee or have any business interests that involve them with any aspect of the racing industry. Well, yes, but with the help and advice of various committees that will be created to guide them. These committees will be made up of experts in the various areas of racing and in medication and testing. Not exactly. The law states that within 1 year of the official seating of the Anti-Doping Authority Board, that rules and regulations must be officially in place. There are a lot of rules to be created and approved in that time, and perhaps the biggest one that is currently the source of the most controversy is that upon passage of the bill there will be a prohibition of any medications being given to a horse within 24 hours of that horse racing. This, of course, means that the usual pre-race medication of almost all horses with Lasix would be prohibited from happening on race day. In addition, until such time as the authority creates the permitted and prohibited substance list for medications and other substances, the initial list to be used will be what has been developed and is currently used by the Association of Racing Commissioners International and the World Anti-Doping Agency. This list will then be modified by the authority after its members are officially seated on the board. Any official changes or list of permitted and prohibited substances will have to be made public and known at least 4 months prior to the date on which the whole program goes into effect, which, as we stated above, is 1 year from when the board officially sits its members. This time frame will allow for horsemen to adjust and be prepared for the changes they will have to make in training and medicating their horses. Until the equine medication anti-doping program is officially approved and in place, all rules and enforcement remain as they have been in the individual state racing commission's jurisdictions. Racing regulations in most states are currently set up in a way that a certain level of some substances and medications are allowed to be in a horse's system when they are racing. It is currently believed, although still vigorously debated, that these levels are so low that they have no actual effect on the horse in a race, but may have been used days or weeks before to help treat a condition in the horse. These levels in medications or substances have been termed permitted to be used in the horse as they are felt to have a therapeutic benefit to that horse. Medications or substances that have absolutely no therapeutic effect in a horse or are designed solely for the purpose of performance enhancement have been deemed prohibited, and so no evidence of their presence in a horse is ever allowed to be found. This includes in what is known as out-of-competition testing that is designed to catch people administering these substances, anabolic steroids and blood doping agents, for example, to their horses at a time in training when their detection would not be possible by the time they raced, but would still have the desired performance-enhancing effects. Nope. Any current cases that are being investigated by the State Commission shall remain in their jurisdiction till their completion. So if this law passes and becomes enacted, all horsemen are starting with a clean slate as far as the federal government sanctions of violations are concerned. Yep, the authority will be the one both creating the level of sanctions or penalties and doling them out. What is kind of interesting is that the law gives the authority the power to sanction not only the humans involved in the violation, but the horse involved as well. Penalizing the horse basically just means prohibiting it from being allowed to race for a period of time, so no horses in jail or anything like that. This has been something some have been demanding for a while now, as it is felt it will be more of a deterrent if an owner cannot run their horse and collect any purse money as a result of a violation, instead of just issuing a fine to the trainer. Yep, there are methods put in place in the law that allows for review of any sanctions given. This review can be triggered either by the Federal Trade Commission or the one being penalized themselves if they file for a review. This review would be carried out by an administrative law judge who would hold a hearing and then render a verdict no later than 60 days from the hearing date. These administrative law judges would be appointed specifically by the Federal Trade Commission to hear these matters and are required to be lawyers with at least 10 years' experience and expertise in the area of horse racing and medication violations. Due process of those accused is protected at all times under this law via normal appeals processes. It would appear the answer to this is yes, as the law would allow the authority to hire their own investigators and other personnel whose job would be to focus more on more rigorous out-of-competition testing of horses. Yep, basically if the law passes, it states that if you want to participate in horse racing in the U.S., you will be bound by the rules of this law. Nope. As was stated earlier, the program is not being run by the government, but rather by a newly created independent nonprofit authority. To start up things, the authority can accept private donations and take out loans to begin its operations. After that, the cost to run the program will be determined on a per-starter basis of horses running in the various states. Each state racing commission will then pay to the authority the amount based on that figure on a monthly basis. Where the state commission comes up with the money for this monthly payment is up to them, but the burden of that cost is expected to basically be shared equally amongst all of the stakeholders in the industry in that state. Well, yes, to the extent of covering this very specific area of racing, and at least for the 5 years after it is passed. After that 5 years, it gets a little interesting, as there are some provisions put in the bill to allow for the U.S. Anti-Doping Agency to back out of being in charge and hand power back over to a state compact that would have to be approved by a certain percentage of racing states and cover not less than 90% of the races that happen in the country. Trying to figure out exactly the legal wormholes that might create in the industry when it comes to this specific part of racing is something that we're just not even going to bother tackling right now. So, I hope that kind of answers at least some of the questions and breaks down and makes the Horse Racing Integrity Act a little bit easier for everybody to understand. I think there are some people in the industry that are really pushing this and feeling it's going to be the cure that racing needs, and some people really feel it may not go as far as it needs to. So it's probably a very important first step if it does pass. The good news for those that are supporting the bill is that it does now have enough co-sponsors to technically pass the House on a vote if it were to be brought up for a vote in the entire House. There is very similar legislation that has been proposed in the Senate, and that has picked up 24 co-sponsors in the Senate, to my knowledge, right now. So they're not quite at the threshold they would need to go ahead and pass it if it were to be brought up for a vote. And nobody really knows if it's going to move further out of committee this session or not, but it has been brought back session after session, and it has been gaining more traction. So definitely something to keep your eye on. Definitely something to tune in and watch that subcommittee hearing on Tuesday if you can. We don't know what witnesses are going to be called to give what testimony yet. It'll be very interesting to see what that list is as well. But we, of course, will be covering it here all on Thorofan, and as always, for the most important, unbiased, and true information about things going on in the racing industry today, there's only one place to turn, and that is right here at Thorofan.